Hey Warriors, this video is for both U.S. history and U.S. government, and this is one of those extra videos that explains some information that's going to be helpful for you to know for both classes. And we're just going to give some basic information about the Supreme Court today. The Supreme Court is made up of 9 Supreme Court justices, and I've drawn those out there, those 9 little heads. Those are supposed to be the wisest legal minds in the country. Those Supreme Court justices were appointed by a president. When they were appointed, they were then examined by the Congress, and the Congress either approved them or sent them back. In this case, they were all approved by the Congress, and so they were then chosen to be Supreme Court justices, and they were appointed for the rest of their lives. They can retire if they want, or if they did something really horrible, they could be removed from the position of Supreme Court Justice. But many, many times, people serve in the capacity of Supreme Court Justice for the rest of their lives. And so we have 9 Supreme Court Justices. There is one Chief Justice who is in charge, who kind of directs the proceedings, everything that goes on. And then there are 8 Associate Justices. Those are just the regular Supreme Court Justices. And so that's what the Supreme Court looks like. Right now, we have had 2 new Supreme Court Justices placed on the court in the last couple of years. They're both in their early 50s. They could be on the court for the next 30 years or so. We'll also have some people retiring and moving on probably pretty soon. Ruth Bader Ginsburg is one woman who's on the court now, and she is probably thinking about retiring pretty soon. She's very old. She's also got some health problems. She could pass away. And whoever is president when that Supreme Court seat comes open gets to appoint a new justice, and then Congress has to approve of them for them to take office. When the Supreme Court decides to examine a case, it has come up normally through the appeals process in the country. So maybe I get convicted of a crime in El Paso County Court, and I'm dissatisfied with the judge's decision, and so I ask if the federal judge, the district court and district judge in Denver can take a look at my case. Maybe that judge decides, yeah, the lower court, the county court got it right, you need to sit in jail. And I'm still convinced that my civil rights were violated or something was done in an incorrect way in my case. And so I can continue to ask more powerful courts if they'll look at that case. The last court in the line of powerful courts, the court that is the boss of all the other courts, is the Supreme Court. The Supreme Court gets probably 7,000 or 8,000 requests every year from people who are wanting them to examine their court case to see if the lower courts got the decision right according to the Constitution. The Supreme Court's only 9 people, and there are only 365 days in a year, so they select probably between 100 and 150 cases every year to examine and to make a decision on. And so everybody that wants the Supreme Court to look at their case doesn't get that. Only 100 or 150 cases are examined and decided on by the Supreme Court each year. When the Supreme Court looks at a case, they'll look at all the lower court decisions, they'll look at the evidence, they'll look at interviews, they'll look at everything that they can get their hands on in regard to that case, and they'll also examine everything that was done and compare it to the procedures and the rights and guarantees that are laid out in the Constitution, because that is their standard. That's kind of their measuring stick. They're going to compare what was done to what is supposed to be done according to the Constitution and see if it was right or it was wrong. Sometimes they'll decide that a law shouldn't have been written in the first place, and they'll declare that law unconstitutional, and the law goes away. You can't make a law like that anymore. So this is an extremely powerful position that the Supreme Court and these Supreme Court justices are in. So after they look at all the evidence, after they argue it out, they take a vote. And that vote is typically going to end up with one side winning because there's an odd number of justices on the court. It's hard to get a tie with 9 people on the court. Now sometimes if someone refuses to vote, or maybe there's a vacancy on the court, maybe someone died and they haven't been replaced yet, if there is a tie when the Supreme Court votes, the decision goes back to the last court that decided that case. And so they just default to the lower court's decision and they essentially make no decision at all. But usually there are 9 members on the court, and usually you have a vote like 6-3 or 5-4 or 8-1 or 7-2. Sometimes you'll have a unanimous vote, 9-0. But let's say that there's a case and the vote ended up being 6-3. The 6 are the group that's called the majority. They won the vote, they're in the majority. The 3 are referred to as the dissenting voters. To dissent means to disagree with. And so those voters, those 3 Supreme Court justices, disagree with the 6 other ones, and so they are the dissenting voices or the dissenting votes on the court. After that case is decided, both the majority and the dissenting group will write what's referred to as an opinion. And this is basically a paper that explains what each side was thinking that caused them to vote the way they did. And so one of these 6 members of the majority will write the majority opinion. They will write about facts of the case. They'll write about previous Supreme Court decisions that they relied on, and they will explain their thinking, explain their reasoning why they voted the way they did. And in the same way, the dissenting opinion, one of those justices will write a dissenting opinion explaining why they disagree with the majority opinion, why they looked at the same evidence and the same court case documents, and they came up with a different decision when they voted. And so these papers, these opinions, are published in something called the Recorder. And often, what the Supreme Court justices write become part of the accepted legal language of the country. And often, those decisions will set what's referred to as a precedent. Not a president, but a precedent. And when someone sets a precedent, it means that a decision is made that other people later on can refer back to and rely on when they're trying to make a decision. For instance, in the case Plessy versus Ferguson, a precedent was set by the Supreme Court when they said to the state of Louisiana, it's perfectly okay for you to force people who are white and black to ride in separate train cars. That set a precedent, and it communicated to the country and to lawmakers throughout the country that you could make any kind of law you wanted to keep white people and black people separated because it's perfectly okay according to the Supreme Court. That was a precedent that was set in 1896. In 1954, in another famous Supreme Court case, Brown versus the Board of Education of Topeka, Kansas, the Supreme Court reversed that precedent when they said forcing white children and black children to go to different schools just because they're white and black is not correct according to the Constitution. It's not okay. It represents racial discrimination, and it does emotional and intellectual and psychological harm to those children, both black and white. Well, that 1954 decision reset the precedent, meaning no segregation laws are not okay. And then after 1954, you saw a lot of other challenges being made to laws that were made to try to separate black and white people from one another. And they used Brown versus the Board of Education. They used that decision, which was a unanimous 9-0 decision. They used that decision to challenge those old segregation laws, those old Jim Crow laws. And because the Supreme Court in 1954 set a new precedent, those laws then, those Jim Crow laws or those segregation laws, began to kind of fall like dominoes. So that's a little bit of information about the Supreme Court. We talk about a couple of Supreme Court cases in U.S. history class, And basically the last half of government class is our talking about Supreme Court cases. So this will give you a little bit of insight into why we talk about the majority opinions and the minority or dissenting opinions of the Supreme Court. Thanks, Warriors. See you in the next video.